Good morning. Welcome to our live webinar. Today's topic, care and contact disputes. When do I approach the courts? The courts could either be the High Court, the Children's Court, maybe the Divorce Court as well, if there's a dispute and you're getting divorced. Nonetheless, today's topic will deal with that issue. And basically, the reason why I chose this topic today is that many people constantly approach me and ask me, Advocate, should I take my issue to court? What other options do I have? I do not want to go to court. I would like to resolve this matter out of court. What can be done? So that's the narrative, and hopefully we can work from there. Obviously, there are many other videos which I have posted dealing with this issue. What I have noticed is that every time I post another video, people may have an additional question, or there may be people that never had questions when I have posted the video initially, and now they have questions, and this video might relate better to them. If you have any questions, you're welcome to make use of our Facebook Live interaction, the Advocate Muhammad Abduroaf Facebook page. Please make use of that specific Facebook page. I'm logged onto that page and I can see any questions that are posed there. If you are watching this video later on, you're welcome to post a question or a comment later, but I cannot guarantee that I will get to it. As we post more videos, we seem to be unable to keep track of all the comments, and sometimes the comments comes weeks or months later. So where do we start? Number one, care and contact disputes. What are we talking about here? Obviously, there is a minor child involved or minor children involved. Mother and father, child. Disputes comes where the parties live in different homes. There will not, I cannot see there being a possibility of there being a care and contact dispute if the parties are living in the same home. There could be parenting disputes there. Possibly, yes, maybe the father wants a child to go with him on holidays or spend certain days of the weekend with him only. So that could maybe be a possible dispute they could have, where the father says, I'm spending a little time with my child, the mother is spending a lot of time with the child, or the daughters or the sons, although they're living in the same home. But 99.9% of the time it will be a scenario where the parties are living in two separate homes. So they had a child together, either when they were living together or were not living together. But here they have a dispute. The one parent says, I would like to have contact with my child, I would like to see my child, I would like to have visits with my child. And the other parent says, okay, maybe you're welcome to see the child, but on my conditions or under these circumstances. What could those circumstances potentially be? It could maybe be that the one parent might say, you may only see the child at my home, supervised by me, or only at a shopping mall or at McDonald's once a week or once a month. Or you may only see the child when I decide so, because I'm the parent of the child, the primary caregiver, and I know what's best for the child. So these are the disputes that arises. The other parent obviously will be aggrieved by that, because he or she may believe, rightfully so, in many cases, that he or she has a right to have proper contact, adequate contact with a minor child, and the child has a right to have proper contact with the other parent. Now they have a dispute, or an issue which I dealt with recently, quite a few times recently, more than twice at least, whereby the custodian parent says, the child does not want to go to the other parent, and I would like to respect the child's rights. The child is about 7, 8, 9 years old. My view on that is, number one, obviously we look at holistically what's in the child's best interest, but it's not for the child to decide what's best for the child. Then I come with a converse or the question I pose back to the client and ask the client, okay, if the child goes to the other parent and the child decides, now I would like to stay by the other parent now for another 2 weeks because the nephews and nieces or the cousins are flying down and there's a party over there, would you be happy with that? So the child can now decide not to be in your care any longer and now live with the other parent. Of course I won't be happy with that. Then they come back to the principle that the kids should not decide. But nonetheless, these are kids' family issues. There are lots of emotions involved, and it's not always that easy to fit every scenario into one box. There's a lot of history, a lot of issues, past events that has occurred. Um, each parent cares for a child differently. The parent exercising contact in one scenario might be different to the parent that exercises contact in a different scenario. So those are the dynamics. The history is different, as I mentioned earlier on. You might have a scenario where parents used to co-parent very well. The child used to spend a lot of time with one parent and a lot of time with the other parent. However, that is no longer the case. So obviously those scenarios would be different to a situation whereby the minor child only saw the other parent once a month, or since birth until 4 years old he never saw the other parent. So those are the situations we deal with on a daily basis. How do we resolve it? Let's start. Let's get a move on this specific topic. And those of you who are watching, thank you for watching. I can see you all live. If you are welcome to say where you're coming from, where you're watching this video from, Gauteng, KwaZulu-Natal, Western Cape, whatever the case may be, and feel free to say hi. My starting point always is, do not litigate from the word go. Litigate meaning do not approach the court from the word go, and do not approach maybe a lawyer from the word go, an attorney or an advocate. Of course, there are scenarios and situations where it calls for an approach to the High Court or to the Children's Court. Yes, that's of course, those are the exceptions. But in general, 9 out of 10 times, try to resolve this matter without approaching a court or a third party or another professional. Another professional could be a mediator or a social worker or an attorney, etc. Why do I say so? The reason why I'm saying so is simple. At some point, if the matter cannot be resolved, the matter will obviously be before a court, before a magistrate. And the question is always posed, or most of the time posed, or put to the other party, in the papers or on the witness stand. Why did you not try to resolve this matter without third-party interference or assistance? Why did you not do that? Why did you not try to speak to the other party? Now, speaking to the other party can be simple. It could entail whereby you ask the other party, could we have a meeting? Maybe he or she should have contact on a Saturday, arrange to maybe meet at McDonald's. I'm using a silly example here, and let's discuss quickly how can we resolve this matter without approaching third parties, and put on the table if this cannot work or it is not working and therefore needs some assistance, but can we resolve this matter without approaching a third party? If the other party says no, I am adamant, I believe this is best for the child and this is how it will work and it cannot work any other way, then of course you have to approach a third party. But do that. So if you do instruct me in your matter and I draft the court papers and appear before the judge or the magistrate, I can tell the magistrate, my client has tried to resolve this matter outside of court on a certain date. Here's the WhatsApp messages. This is the details of, these are the details of when they met and what was discussed. It might be in dispute, but it's one box that has been ticked off from the list that could potentially cause issues in the future. Then we go further. If that doesn't work, hopefully it does work, but if it does not work, and then I strongly advise people to seek the assistance of third parties. Here I'm talking about mediators, not lawyers yet, not attorneys yet, not legal representatives. Many attorneys and advocates are mediators. Same thing, they are mediators. They are wearing the mediation cap. They can't represent you afterwards because they acted as a mediator in a matter. So approach a mediator, FAMSA, FAMAC, there are many other organizations. Go to Google, type in mediator, Cape Town, Durban, Gauteng, KwaZulu-Natal, wherever it is, just type in there, you'll find a few organizations. Each province might have different organizations that I know for a fact, and approach them and send them an email saying, obviously, consider the location. If you are living in, for example, Cape Town, do not look for a mediator that's more than an hour's drive, maybe half an hour's drive. Find someone close to you and the other parent. contact the mediator and advise them, I have an issue with regarding care and contact. I try to resolve it. It did not work. However, I am struggling. That is fine. Could you please advise what's the way forward? Now, different mediators will of course have different ways of dealing with the matter. Some would prefer you to sign a instruction manual or some type of document stipulating that both you and the other parent agrees to the mediation, which is very important, agrees to the fees, agrees to all of those things, because the mediator might not want to get involved at this earlier stage trying to contact the other party on your behalf, because the other party might say, but you contacted the mediator, you spoke to the mediator, and the mediator is now on your side. Obviously, we do not want that to happen. So the mediator might have certain point of references or terms of engagements, etc. Or some mediators might say, I prefer, okay, thank you, this is your email, I'll forward this email to the other party and say I've been approached, I can assist the parties. Whatever he or she feels is workable and will avoid any problems happening in the future. It depends upon the facts of the matter. If the mediation works and it is a proper mediation, wonderful, we resolve this issue, parties are happy, a parenting plan should be entered into. That's now the term we'll be using going forward. Parenting plan. Obviously, if you're resolving this matter with the other party on your own, you do not know how to draft a parenting plan. You have some type of parenting arrangement, some type of plan. It might be a one document, child is with you, goes with the father or the mother every second weekend, and school holidays are being divided into half. Mother's Day, Father's Day, religious days, Christmas days, New Year's Day, Easter, etc. Those are divided in a certain way. But that's fine, that is fine. You do not have to have some type of a legal document like a professional parenting plan. I would also call that a parenting plan if it's done between parents on your own. It's your plan, how to parent the child. But the more formal word obviously apply where a professional got on board in drafting a legal document signed by both parents. So you meet with the mediator drafts a parenting plan. Wonderful, that's good news for me because it means there's progress. Things are now happening, things are moving forward. Finally, the mother can say what she wants to say, the father can say what he wants to say. Both parties are now forced to listen to the other party. Very important, because what often happens is the moment the parents divorce or separate or no longer live together, or they come to this issue now regarding the child, the topic changed. The topic is now the child, no longer them. They no longer listen to each other. They hear each other, but as the father opens his mouth and he tries to explain to the mother why he needs to have more contact with the mother, that starts at 12 o'clock on the dot. Then 1 second past 12 o'clock, the mother's brain is starting to create a response, a rebuttal to the father's argument. So she's not listening to the father, she's creating a response to his specific argument. And at the same time, when the mother speaks, and she tries to explain to the father in good terms why the contact proposed by him is not in the minor child's best interest, at 12:15. At 12:15 and 1 second after that, the father's brain starts calculating and creating arguments as to why the mother's arguments are weak or not strong, and that his argument should apply. So they're not listening to each other. And they can continue and go on for weeks and months and sometimes years. But in a mediation session with a professional and a skilled mediator, somebody tough, not somebody that's here to put down their views as to what they think is best for the parents. No, the parents must decide what's best for them, not the mediator, but someone that will allow each party to voice their opinion and their views, reasons why they believe certain care and contact arrangements should be in place. Both parties should speak, and both parties are forced to listen to each other, because what happens is if one party speaks, the other party might not listen the first few minutes, but at some point the other party will have to listen, because that party will be speaking for the next 20 minutes, and that party learns to calm down, because the mediator says, your 20 minutes or your half an hour, your hour will come. It's not yet here. So you have no other alternative but to just listen to the other party, and that's very important to listen. Might not agree with the other party, but listening is extremely important. And after the other party has spoken, you will speak as well. And then there could be some reasons for dialogue, for discussions, but it needs to be in a controlled environment, or a controlled forum where people aren't just standing up and shouting and talking over the next person, almost like a court of law. One person speaks at a time. How will a court of law be if the judge speaks and the lawyers are um, saying something or asking the witness questions, and the witness is talking, and the lawyer and the witness is arguing with each other, and the magistrate or the judge is arguing with the lawyer and the witness, and if the other party objects and stands up and say that cannot take place, how can you ask that question? Four people, the witness, the two lawyers, and the magistrate, all talking at the same time. That will be chaos. Nobody knows what's happening. There's no control. That's why we have a judge to obviously control the proceedings. And obviously, that whole exercise of everyone speaking at the same time was futile. It meant nothing happened. Okay, so let's move forward. The mediation took place. Two scenarios. Number one, after a few days of mediation, or they came back the next day after they thought about what the other party had to say. But number one, the mediation is successful. Okay? Of course, the other scenario will be not unsuccessful, but the mediation is successful in this scenario. The mediator will obviously now try to assist the parents in drafting a parenting plan, because they agreed on a lot of things. They agreed upon the issue concerning where the minor child should primarily reside. Should it be with the mother or the father? They agreed upon the issue as to when the other parent should have contact with the minor child. This progress. They agreed upon the issue concerning maybe child maintenance. What should be applicable, what should not be applicable. Or they agree on the issue concerning no child maintenance goes to the maintenance court. Results. We're moving forward here. They might disagree on the issue concerning Father's Day and Mother's Day, on Christmas Day or on those days, but that is fine. They can maybe stipulate, those issues for now can be resolved in a different fashion, or they can have some type of clauses where one party will say, you know what, this is my preference, but if it doesn't work, I'm happy with that. So they come to some type of a compromise. Both parties want this matter to be resolved. It's very important for their own psyche and the psyche of the minor children involved. Emotional and psychological well-being. Very important. It's not only the minor child that gets affected by this, the parties get affected by this as well, just as much. And children are very resilient. Children have no basis on which to compare their situation with. This is their first time they're living life. If the parents say the child should live with a dad for 1 month and a mother for 1 month, for argument's sake, children do not know what to compare that with. They believe that it was probably the way life is. Same with the lockdown, COVID-19, where young kids, this is normal. I mean, school at home, homeschooling is the norm. Going to school every second day became the norm afterwards. But obviously, kids that are in high school during the lockdown, they had something to compete with. They can say, "Yo, this is totally not on," or they might enjoy it because they're comparing it to when they went to school every single day. So I think you know where I'm going to. Nonetheless, the parties came to some type of a compromise, some type of document, a parenting plan that's applicable to their specific situation, to their scenario, to their family, to them, no one else. It's important to note that a parenting plan applies to your specific situation, not to mine, not to his, not to hers, not to the 1,000 files I had before this, and not to 1,000 files I'll still be dealing with for the years to come. Your situation, it might possibly be that your situation might be the same like someone else's, but it does not mean that. Your kids are different. Their needs are different. Your financial circumstances are different. The distance between where you live and the other parent lives are different. Your working hours are different. The type of work you do are different. The extramural activities the kids are doing are different. The list goes on. You follow where I'm going to. Therefore, the parenting plan must be customized, made for you and your kids. And of course, yes, it's possible to have a generic type of parenting plan deal with every second weekend. That is fine. If the parties are happy with that and the parties can live with that, I do not see any issue regarding that. But I always say a well drafted parenting plan is a parenting plan that is specifically customized and made specifically for the specific parents involved. So I hope you with me on that specific point. Okay, let's move on. If that parenting plan is drafted, well drafted and signed, then what happens next? It can be registered at the Office of the Family Advocate, or it can be made in order of the court. I prefer it to be made in order of the court, obviously because you have a court order. And if one party does not comply with the parenting plan, then obviously you take it to the police station and then charges can be laid, or they might be able to assist you for the compliance of the parenting plan. But now you have a parenting plan that was registered at the Office of the Family Advocate. You need to explain to them the legalities thereof and all of that. It might be a bit challenging, a bit difficult, but nonetheless, either way, registering the parenting plan at the Office of the Family Advocate or having it be made in order of the court is just as well, just as good. Now let's deal with the other scenario where the parties cannot agree on a parenting plan. The father is adamant, he is a primary caregiver of the minor child. He does not want the mother to have contact with the minor child other than every second weekend and maybe a day in the week. He has no issue with half school holidays. The mother says no, she wants to have 50-50 care and contact. She wants shared care where the kids remain with her from a Sunday evening until the following Sunday, maybe from 5 p.m. the one Sunday until 4:59 the following Sunday, where the change takes place. And she believes that she's entitled to have video contact as well during the week. It will not interrupt the children's schooling. Of course, each circumstance are different depending upon the age of the child, etc. But there's a impasse. They cannot agree upon it. What happens then? Then, of course, at that specific point, my advice to you is, seeing that mediation has failed, the attempt has failed, my advice to you is to approach the courts. Now you could hear what I said. I did not say approach a lawyer. I'm not here to start to work for attorneys or advocates. Approach the court. You have the option of the children's court, where it does not cost anything. It's free. And you do not require to have a lawyer. It's always advisable to have a lawyer. The same way if my car is broken, it requires a service. I can service it myself, or I can make use of a mechanic to service it for me. But the premise is I do not have to make use of a mechanic. I have the option. The same with court with legal matters. You can represent yourself in legal matters. Of course, it's advisable to make use of an attorney or an advocate to assist you. You approach the court. Now you have to now determine, is the matter very urgent? Now the children's court does not necessarily have urgent care and contact applications. The way the system works, the architecture of the children's court basically deal with, if it is dealt with urgently, they bring in social workers, they put the child in foster care and stuff like that. Where the High Court has a urgent system whereby you can approach a High Court 24 hours a day, 7 days a week, 365 days a year on urgent matters. It must be very urgent, and the court will entertain and deal with the matter. But that's something I leave for another day. If you can afford legal representation, if you can afford it, if you have the money available, meet with an attorney or trust account advocate and take it from there. They'll be able to advise you what's the best way forward, depending upon the circumstance and facts of the matter. If you have contact, you are seeing the child, but you're not seeing the child enough, then the matter might not be so urgent to approach a High Court judge, at 2 o'clock in the morning. If, however, the matter is not that urgent, or if you cannot afford the legal services, go to the children's court, full stop. Do not even consider the High Court at that point, because it might be a bit difficult and a bit technical for you to deal with that. Go to the children's court as soon as possible, lay a complaint, fill in the forms, and the children's court will deal with the matter. They'll call both parents in, and they'll try to resolve the matter from there. Okay, I'll stop the issue concerning the court here. However, I would like to say the following. Ultimately, whether or not you approach the High Court or you approach the children's court, ultimately, the court will make a decision as to what is in a minor child's best interest. That's the bottom line. The court might decide to get the Office of the Family Advocate involved, a family advocate usually, most of the time, appoints a social worker that will investigate the issues depending upon the facts of the matter. As I mentioned earlier on, each family is different. If there are allegations of neglect, they will look into that. If there are allegations that the minor child is not properly looked after or does not have a proper living facilities, they will look into that. They will go to the parents' homes and those issues, depending upon the facts of the matter. If there are no allegations regarding any of those issues, but the issue basically is what type of contact should take place, whether or not should be 50-50 or every second weekend reasonable contact, and so on. Or the issue is basically just whether there should be telephonic contact or not. There might not be a need to visit the parents' homes. Depends upon the circumstances. But ultimately, the court will have to make a decision as to what is best for the minor child with all the information before it. You can consider, if you can afford it, to enlist the services of a professional person, a psychologist, a social worker, who can do their own investigation. Of course you can do that. Obviously, my advice to you is to do so with the court's endorsement. You do not want to have a situation whereby the other party says, you paid for this person, you engage with this person way in advance, this person knows you, this person will be biased. We want to avoid that from happening. Therefore, if you are appointing a third-party expert, make sure that the other party is happy with this expert, so we at least resolve that issue of bias or presumed bias or assumption of bias or apprehension of bias. So apologies for that. And once we've resolved that specific issue, we have the court endorse and authorize this person to do the necessary investigation. But at the end of the day, the court will make a decision as to what is in the minor child's best interest. Now, in dealing with what is in a minor child's best interest, obviously the court does not look at what is best for you as a parent. What is best for the minor child is not necessarily best for the parent and vice versa. We focus on what's best for the minor child. But in doing so, I advise all my clients, whether or not I represent you and I fight for you, I can only do my case, or you can only present your case, or the court can only decide the matter based upon how you presented your case, what information was presented. The amount of effort and energy you put into your case will determine the ultimate result. If you approach an advocate, the best advocate in South Africa, to deal with your matter, but you are nonchalant, you just sit back and you're crying on the phone and you just saying, advocate, I need to see my kids, and that's all it's basically saying, and not engaging with the advocate, you're not dealing with the proper issues as to why you believe it is in a minor child's best interest for you to have contact or care or shared care, whatever the case may be, and these are the reasons for that. And then work with the advocate, so when the advocate drafts the documentation or presents his arguments or presents evidence with you on the witness stand, he does so, with all information in front of him, and well thought out, and well crafted arguments or legal presentation. That's very important. So you need to work with the legal team. If you're doing the matter yourself, the same thing applies. You need to put effort into your case, and that's how you get results at the end of the day. Thank you very much for watching. Those people that were online, thank you very much, and I hope you have a lovely day, and I hope you benefited from this video. Thank you very much.